I want to ask you about the definition of fetal heartbeat in the new act. Same essentially as the old act. Fetal heartbeat means cardiac activity, comma, or the steady and repetitive rhythmic contraction of the fetal heart, comma, within the gestational sac. Those commas may or may not have great significance. Do you think that the phrase that is within the commas, the parenthetical within the commas, is actually a phrase that the legislature intended to define the term cardiac activity or to supplement the term cardiac activity? In other words, the question that I'm asking you is simply, is fetal heartbeat defined simply as any cardiac activity, or is it defined as the steady and repetitive rhythmic contraction of the fetal heart?
So I think that the operative phrase would be cardiac activity, and I think that's probably what the legislature intended. I think that is what is measurable typically through an ultrasound.
Well, you're the one making the argument about it could be more than 6 weeks, and I think that probably is not a good enough answer to my question. I want to know what the position of the state is definitively.
So,
because there is a line of cases around the country that attach great significance to that comma, right?
Or the absence of it.
Or the absence of it. And if I'm not mistaken, the Texas definition of fetal activity is identical to this one, except that it does not have the comma.
yes, Your Honor, I understand, and I think the position would be that cardiac activity is what we're seeking to measure in particular, and what the state is seeking to measure, to the extent that doctors are familiar with trying to measure.
But why does it
Well, I'm going to turn you back over to Justice Beatty then, because you just walked yourself into a gigantic hole of ambiguity.
I think I'm letting them stay there. But why is it included then? If it's not needed, if it means just cardiac activity, electrical impulses from that smaller group of cells, if you will, why does it put repetitive contractions of a heart?
I think, Chief Justice Beatty, it can be clarifying in terms of what cardiac activity is meant to measure. But I think that.
So you're saying cardiac activity then means the repetitive contraction of chambers of the heart?
No, Your Honor, I think that cardiac activity is a medical term that has an independent scientific significance. I think that by including that term, the General Assembly was likely expounding on that concept. But I really think that.
When you expound, you explain. And page 10 of the American College of Obstetricians and Gynecologists amicus brief, they point out the problem you have with that verbiage. Cardiac activity, the steady and repetitive rhythmic contraction of the human heart. That may be fair game in an as-applied challenge, but you have to have a heart, which is 4 chambers. You have to have steady and repetitive and rhythmic contraction of that heart, which is perhaps, according to the medical community, a far cry from cardiac activity, or far more advanced than cardiac activity. I think that's what they're getting at, and that may not be an issue today, but I have a question about it as well.
Yes, Your Honor, I think that makes sense, but I think the distinction that you're trying to draw is a good one between whether this is a facial challenge or an as-applied challenge, because I think whether we're measuring from cardiac activity or a fully formed heart, which would be much later.
So that's a box. We need to put all that in a box and set it aside for a later day. Is that what you're saying?
I actually don't think that's necessary.
Planned Parenthood has not argued that the statute is void for vagueness on that issue. They're arguing that it's void for vagueness on the enforcement portions, correct?
Yes, Your Honor, that's right. And I think you could save it for another day, but I think on cardiac activity and that question alone, you could resolve their facial challenge, which is necessary to show that the statute is invalid in all its applications.
Your argument, Mr. Lambert's argument, is this. The legislature is the policy-making body. They have set a policy that abortions are not permitted after a certain point. That is the legislature's prerogative. You and Mr. Lambert claim you have satisfied Justice Few's concerns, so pretty much the game is over.
Yes, Your Honor.
That's what you say.
Yes, Your Honor.
And that requires us to accept a little bit of this with a bit of cynicism.
Yes, Your
You
Honor.
convince one person, so we can just leave.
Well, I think that actually goes to the primary argument where we were opening, and I think that's that the January.
Let me
decision-
just interject here, if Justice James doesn't mind, because the question that you raised in your argument just now, talking to Chief Justice Beatty, is what is the point? What is the point in time? And I think the conversation we're having about the definition of fetal heartbeat goes to that question. What is the point? For example, if the point is 12 weeks, if the first time that an average heart shows a steady and repetitive rhythmic contraction of the fetal heart is 12 weeks, and that's an entirely different question than if it's the first time there's any one-time pulse of what would eventually become a heart.
Yes, Your Honor. But
And see, I mean, that's a big question, right?
I think it is a question, but I think that what we would suggest is that the law, even if you measure at the earlier point in time in terms of cardiac activity, under your opinion, the law still is valid. And
That may be true, but that's not the point we're on. The point we're on is what is the definition of fetal heartbeat?
And I think, again, Your Honor, I think cardiac activity would be the primary line that the General Assembly intended to draw. And I think that would be detectable potentially at 6 weeks gestational age, but it could be later at point in time.
Is the legislature's finding about the detection of a fetal heartbeat being a key medical predictor of live birth essential to the Act's constitutionality?
I'm not sure that it's essential to the Act's constitutionality, but I think it does go to what is the legislative purpose here. And I think it shows why there is a particularly compelling interest in protecting unborn life, which is defined to begin at conception. And I think that's because after cardiac activity, I think the statistic is it's 95% likely that a child will be able to develop and be born.